She does appear because I've heard that.
I can always tell whenever I start something new because it's always a complete chaotic mess. I'm sitting there looking at another screen with me just staring at the screen. Hey, everybody. Welcome to American Courts. Good to see everybody. I hadn't seen you guys in a long time, and it's really neat to be back on the air. Been a busy week. Missed everybody. Some craziness in the YouTube world, but that's always the fun. Thank you, guys. I've got a little screen over here. It's a list of all the channel members. It's a long list. I didn't imagine it had gotten that big. So thank you everybody for that. We got some good videos today. We got Judge Fleischer, Judge Simpson, Judge Hagen. We got a really long one with Judge Washington. We probably won't get to, but we got plenty to go through. So let's start off with the Judge Fleischer one.
Please. Who do we have here, Greg?
Mr. Zenon, Your Honor.
Visit PC, Your Honor. I have some questions.
Oh, you picked up a new case. I'm sorry, I'm just getting wind of this now. I didn't realize this. He just picked this up.
My client or the person?
Yeah, him. Picked up an interference 2 days ago.
That's what I'd like to revisit.
Yeah, of course. So you were on felony probation for a very serious case, evading arrest in a motor vehicle, which carries up to 10 years in prison. Now you've picked up a new case. Greg, I got to tell you that I don't know how much you know, but I have quite a bit of history with Mr. Zenon here. In fact, within the last 2.5 years, 1, 2, 3, 4, 5, 6, 7, 8, 9. Now he's on his 10th case, specifically an unlawful carrying of a weapon, another unlawful carrying of a weapon, another unlawful carrying of a weapon, another unlawful carrying of a weapon, a felony possession of marijuana, felony assault of a pregnant person. And I guess all that worked into a deal where he got on probation for an evading. And now we have.
Right, but all those cases were dismissed, correct, Your Honor? Okay.
Pursuant to the, I guess.
I understand.
That we literally had one after the other, like a rung on a step ladder. One after the other. So let's do probable cause.
Thank you, Your Honor.
You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. I just wanted to give you a heads up of how much history we have with Mr. Zenon, because it's a lot.
I appreciate that, Your Honor.
Sure.
But be that as it may,
I'm not going to hold, I've never will hold anything against him. So let's go.
On December 3rd, 2024, officers were dispatched to the HEB located at 4955 State Highway 6 regarding a disturbance in progress. Officers received 4 calls, all from witnesses who stated the defendant was arguing with and assaulting a female. While en route to the location, officers observed the couple at the intersection about 0.1 miles away from the HEB where the original call was
Observed what?
located. They saw the couple at the intersection.
Okay, they saw.
Yes,
Okay.
Judge. The defendant was uncooperative with officers. The defendant advised he and the complainant were involved in a verbal altercation and stated he threatened her, saying he would slap her. When officers advised the defendant that he was in custody for an outstanding warrant, he got upset and began to yell. Officers located a clear plastic bag containing 3.6 grams of marijuana. The defendant refused to comply with officers' commands to sit down and would not place his legs and feet inside the vehicle. The defendant pushed back against the officer's hand with his chest when he attempted to help him into the vehicle, pushed his legs straight and applied force toward officer's hand in an attempt to stop him from placing his legs inside the vehicle, and then used the bottom of his foot against the bottom of the door frame to further resist. The defendant refused to speak with officers and would not cooperate with the investigation. All witnesses on scene heard the defendant threaten to hit CW, and another witness stated she observed the defendant push the complainant in the chest and face with 2 open hands. He does have an active felony warrant from the Fort Bend County Sheriff's Office for aggravated assault with a deadly weapon
But he has an open ag assault somewhere else too?
in Fort Bend County, Judge.
My understanding is it's
And
an
it was
older
open
case.
warrant at that time?
Yes, Judge.
May I respond to all this, Your Honor?
Sure. Please.
Where's the interference? Okay.
Well, they're putting him in a car and he's like going
How-
blank.
It's not interference with public duties. If they're sitting there saying they have a marijuana charge they could have done, is it a resisting?
So,
Maybe,
well,
but it's not an interference with the public duties. They said he didn't talk. He doesn't have to talk to them. Like, and they're,
I understand
and
that.
they're a 0.1 mile away from the location
So-
for what?
Well, okay, I get that, but so we have what we have. We've got a disturbance at HEB. Cops go there,
Okay.
they start to talk to him, and I guess at that point says, "Hey, man, I'm gonna slap her." So at that point, I mean, that's what we have,
Okay.
right, Mr. Zenon? There's always 2 sides to the story. I get it. This is just probable cause. It doesn't mean that you're guilty of this offense. It's just probable cause. That, in and of itself, is it enough to continue an investigation? And it is, because it's a potential terroristic threat, right? So they have enough to go forward to investigate. They start investigating, and then they find that you have a felony open warrant. And then they find there was something else was there another warrant that you said?
No, it's the aggravated assault, but Judge, I also would like to point out that the.
But
as
they end
part-
up putting him in the car. And at that point, he basically just goes blank like this for them being unable to effectuate an arrest.
And Judge,
I don't think that's an interference.
I don't. I mean, I think the intent of the law within itself is that if you're interfering with their investigation for something else. He did not interfere with anything.
Hold on, let's read the code. Let's read it, because, I mean, there's no better way. Let's read it.
Hold on.
I'll give you, All right. Let's pull up the code.
Intake could have taken some other things, but
Well, certainly, they could have
Okay.
taken a whole myriad of, I mean, you're lucky they didn't charge you with assault of a peace officer. There's a whole host of other charges that they could have put on, you know? If,
but they didn't
Hit.
they took the one that I do not believe applies here.
let's read the code.
Okay.
Let's see what the code says, because, you know, there's multiple ways that a charge can, you know, that you can charge someone with facts, right? There's multiple ways that can, it's 3815.
That's okay, don't worry.
You're right. It could have been like a resisting, you know, but. Okay, you ready? A person commits an offense if the person with criminal negligence interrupts, disrupts, impedes, or otherwise interferes with, number one, a peace officer while the peace officer is performing a duty or exercising authority imposed or granted by law. Two, a person who is employed to provide emergency medical services, a firefighter. Number three, for an animal under supervision. Now, So I guess it's a person, it interrupts, disrupts, impedes, or otherwise interferes with, number one, a peace officer while the peace officer is performing a duty or exercising authority imposed or granted by law.
That is the vaguest thing I've ever heard in my life. I mean, come on.
It is. I agree
Okay,
with
so
you.
the cop can claim anything is interfering with public duties. I mean, constitutionally, that is the vaguest thing I've ever heard of.
Judge, that's the statute, that's the penal code.
You'll find no argument with me, right? It is pretty vague.
Yeah.
It is.
He's got bigger issues. I mean, they should have taken the other charges, my whole point. I mean,
But he's disrupting the officer while he's trying to discharge a duty, right? The officer's trying to arrest him and put him in the car, and he's not letting him do it.
I mean, that's assuming they even had the right to do that. I mean, he's 0.1
It's an
miles
open
away.
felony warrant.
They didn't even know about the warrant. They didn't know about the warrant till after. So, I mean, that comes after all of this.
They're saying, go ahead. I didn't even give you a chance to talk.
No, you're okay,
Please.
Judge. They were investigating the assault, Judge, is what or the threat that he admitted to making. So it was an active investigation, and then when they were detaining him, he was resisting arrest, is what it seems like. And that's why it was charged with interference with public servant.
And there were also 4 911 calls that were made about this couple arguing. I mean, that's what they were investigating.
And the witnesses all
They
described.
put
the-
him,
the
I guess,
defendant.
did they put him under arrest at the time when he said that he was making that threat?
And with being.
I mean,
0.1
did they
miles-
have the authority to arrest at that time? Right?
So I think it was during their investigation, the defendant admitted to threatening, that he would slap the misclaim.
And it's at that point they start to put him under arrest?
At that point, they ran him through the NCIC and they found that there was an active warrant, and then they informed him that he was in custody.
Okay, then that's a resisting from what they're using to say he's pushing back or
But
pushing.
remember,
That's
I
a
mean,
resist.
it-
That's not
it
interference
could
with public
be-
duties.
But it could be that a set of facts can be multiple charges, right? So it could be resisting, but it could also theoretically be interfering with what he's trying to effectuate which is an arrest. It's a duty that he's performing. He's performing the duty of an arrest.
But again, it's vague. If the officer didn't put in the report, he's not saying in the dim summary, you are under arrest.
We don't.
Well, I mean, it's,
Okay, well, I mean, but so
I mean,
this
we
is,
don't know. I mean,
okay, I'm just saying.
if he says he's under arrest, but I mean, damn, it's all but clear.
I mean, this is,
We also
And
don't
yes.
have the offense report
We
yet,
don't
I
Judge.
don't
That's
care.
where
I
he
mean,
was in
but
the
I think that there's
process.
enough, he places him in custody, right? He's going to arrest him, starts putting him in the car, and dude goes plank.
Oh, I see. I know, but I don't have the video.
I
I've
mean, I
shared the
think that-
videos with.
Remember-
You're right, I haven't had a chance.
Guys, this is a very low burden. This is probable cause. This is not beyond a reasonable doubt, you know? Beyond a reasonable doubt is a different standard. This is just to see if there's enough to go forward. And according to this, you're disrupting, allegedly, you're impeding, and you're otherwise interfering with him trying to arrest you and putting you in the car. A person can interfere with duties in multiple ways. It's not just one way. Like you go in there and someone else tries to stop an arrest from happening. I don't know. I think that there's enough.
Whisper to me because I want to know what you're about to say.
And if you want time, you guys can go back and talk.
Okay, well, I gotta say,
Required 3 times to search me.
can I have a moment to look at the video here? He's telling me a whole separate fact pattern.
But I need to give them time to be able to look at it too. I mean, it's noon. Why don't we do this? Why don't we roll it to Monday and we can, I'll find it now. We can reapproach Monday morning or tomorrow even. And if you find,
I mean, because
if you find a completely set of different facts than to what they're saying on video, I'm all ears. I'm always all ears. I'm always willing to rehear probable cause at any time. I mean, it's not the be all end all. But for now, what they're telling me, if it in fact is the case, there's enough for probable cause to go forward. Is there enough beyond a reasonable doubt? I don't know. But be that as it may, you know. Okay, it looks like they didn't give him a PR bond on this.
Okay, so well, then we can
The
address it.
bond right now is set at 2,500.
Okay,
Your bond upstairs is set at 5,000. Tell me about that Fort Bend case. Is it old? Is it new?
Let me check, Judge.
I think it's 2023.
Is it? I don't know. I mean, because looks like you got on probation in October of this year. When you're on probation, dude, on felony probation, you have a freaking halo over your head. You know, you got to be as good as you can. You're facing a lot of time in prison. Have you been to prison before?
Sir. No, sir.
It's not a fun place, you know, and I don't know what we need to do to get your attention, man. In life, if you're with a person that brings the worst out in you, then don't be with that person. There's a gajillion and one fish in the sea, but how can a person get you so wrapped around your finger to make you, you know, just go. It's like a cancer. When you have cancer, if you don't cut it out, it kills you. This is killing you.
I can contact Fort Bend Judge and get more information.
Well, it doesn't matter. It's neither here nor there. I'll do whatever you want to do. You want to set
I mean-
tomorrow, Monday, what in?
I'll watch it today and come back tomorrow if you want.
Yeah, I mean, if you want. Surely. Do you have it?
We have the camera, the body cam.
I just shared
Okay,
it.
so
They
Let's-
shared it, they just shared it with me.
Yep.
let's roll it to tomorrow. You guys take a look at the video as well. Be prepared, and then we can reconvene tomorrow. For purposes of now, I'll find probable cause, and then we can regroup again tomorrow.
Okay, thank you.
Okay, all right, Mrs. Zenon.
Thank you.
See you tomorrow.
See you tomorrow. Yeah, give me a second.
Morgan, I don't, is this yours? Remember, we're back on Zenon, or?
Probably gonna agree to disagree here. But I would like for you to watch like the 2 minutes of the video that I think.
So Judge, I also, because you had this question yesterday, I called Fort Bend and they confirmed it. The Fort Bend County aggravated assault with a deadly weapon, it's just sealed, and that's why I didn't pop up.
It's
for
just
it.
what?
It's sealed at the moment.
Sealed. Is it a new case? Is it an
It
old
was
case?
just filed in November, Judge,
Wow.
but the offense date was in March.
Okay, so that's what I'm asking. It was the offense date was March of 24.
Yes,
So it was allegedly committed prior to, now nevertheless, it's still a
it
warrant,
was,
but how on earth has it never been?
it's because, so they'll unseal it whenever an arrest happens, Judge. The case was filed. He had 2 other charges in this county, even that he caught even after that one.
I'm so confused. You know that there's a, Fort Bend knows that there's a felony warrant, a dangerous felony warrant, and they failed to execute that warrant over and over. He's been on probation. He's been
Judge,
meeting with his,
Reading in here that he's got on 2 years probation for, and then had also a UCW here that he caught after that. And another assault of a pregnant person that he caught here after that, and then another UCW that he caught here after that. So he had just a string of cases, and I mean, the list goes on. But there was just a string of cases that he caught even after that, so I guess they just never, I don't know.
I will tell you the shenanigans from my experience that Fort Bend does. So if they think they're going to TDC, I have seen them, let them go to TDC, wait till they even make parole or discharge or finish that sentence, right? And then they're out and they go, oh, now we're gonna file you. And then parole goes, oh, now we're gonna revoke your parole. Those are the shenanigans that I've seen.
Judge, I
And this
can't-
has been going on for years out there, like prior administration continuing.
but I mean, I guess ultimately at the end of the day, even if that happens, like, let's just say the parole board's gonna look and see that was like extremely old, right? I would have a think. So
So you're gonna extend him for 6 months,
Yeah.
you want a short reset,
very short reset, like
30
maybe
days?
3, no, like 2 weeks, 3 weeks to make sure that he's paying.
Okay, great, 2 weeks, 3 weeks, that's around
how-
holidays. So can I make it like first, 4 weeks in
Okay,
January?
yeah. So
Joe,
It should-
oh,
Joe,
Yes.
so what I'd like to do is, I guess, set it every couple weeks to make sure that he's paying into the registry, to make sure he's paying. First time he doesn't, then,
so.
oh, what's that?
So, excuse me, Shatoria said that he can't make payments to the registry. He's gonna have to pay it in full. So he's gonna have to,
What?
Joe has to.
So how do they say that he's got 2,200 then, or 2,100?
So he has 2,200 saved. He told him I have 2,200 in my
Oh,
bank. So
So.
he's gonna bring that to my office on Monday. And then I'll stick that on my IOLTA account.
perfect. Then I'm happy to do it that way.
Okay.
I so trust you.
Mhm.
If you tell me that he's been paying you,
Yes, sir.
I'm happy.
Okay, sir.
So let's do this. Let's set it to Monday. I want to know that he's paid you that, at least that amount.
Okay.
And then we'll set it every, 2 weeks after that to make sure that he's paying you. And it doesn't have to be much, it could be, 50, 75, $100, but I want to know that he's faithfully paying it off. And then, or we can, calculate, or have him tell me what is a reasonable amount every 2 weeks.
Yes, sir.
And then
Parents gonna be waived every 2 weeks?
if he pays,
Okay. Okay.
the first time he
I
fails
don't, I'm not gonna read it. Doesn't matter.
is in,
I mean, it doesn't matter. It's on video. It
So I'll
doesn't
make a
matter.
note. Okay. Parents required, but no,
correct.
if he
Right.
pays.
On video, guys, like I watched it. I'm not crazy. Like this, it's on video.
Sorry to keep
Let's
waiting.
talk to Judge about it.
Okay. You're still upset?
Yes, watch the video and I'm even more upset,
So-
Judge.
So Judge, we just want to address some of the questions that defense and you had yesterday. Defense was saying that he felt that interference statute was overbroad. We found case law saying that it's, or vague, that it's unconstitutionally vague. We found case law saying that it's not unconstitutionally vague. It's from DeContal versus State. I've tendered it to defense. Can I
Sure,
approach
of
Judge?
course. I gotta imagine that if it was unconstitutionally vague, someone would have challenged it and it would have,
Well, maybe I haven't had my case yet.
Okay.
and, I'm happy for you to make new law, always.
Judge, did I hand you DeContal versus State? I did, just,
The Canto,
yes.
yeah. Oh, look, it's out of Court 8 in Harris County.
That's for this case.
So why are you saying that there's no PC in this case?
Is there PC for something else? Yes. Is there for the interference with public duties? No. I mean, because it's on video, it didn't happen, Judge. So they get calls for an assault, a disturbance,
You're
whatever.
telling me the fact that they're saying he goes plank in the car while
He
he's
doesn't.
being arrested
He
doesn't
does
happen?
not go plank. It's on video, Judge.
Would they say he uses his, I guess he uses
He's in
his,
handcuffs.
The officer has to place his hand on the chest of the defendant to get the defendant to sit back in the car. He also has to grab his legs and push them back into the car. We also watch the video.
We watched the video and we have a timestamp, Judge.
could it be that okay, so I know that a lot of times when they're putting a defendant into the car, they need help, right? They're unable to do it by themselves, or is he actively resisting getting into the car?
He tried exiting the vehicle, Judge. And
No,
that's
he-
why they had to push him back into it.
He leans forward. He's yelling at his mom, record, call. The third time they have taken him out. This is 3 times. They put him in the car and they take him out so they can search him. The cop is sitting there going, oh, well, search him again. We can search him 20 times. If you feel you need to search him 20 times, search him 20 times for your safety. The cop doesn't even know what he's charging him with. DA hasn't been caught. The cop's sitting there go, we're getting you for resisting transport. Resisting transport. That is what the cop thinks he's taking of it. DA, Officer Singh, it's a 27-minute video. Okay? At no point is the DA's office called to this point. Okay? That happens after. Fine. For an assault, they can argue. I can argue case law. Ford v. State, specific articulable facts of crime may have occurred. Fine, they are there on an assault. Okay? They didn't take an assault. So then they detain him, right? They find that he has the warrant. So, okay, you're taking him in on the warrant. Fine.
Judge, it's
It's all-
common for officers to conduct an investigation before they call intake. That's not an abnormal
Yeah,
thing.
I mean, that's neither here nor there, but the question is he impeding the arrest or the function of arrest? Because I guess that you guys are basing the interference on the fact that he's not allowing him that, what's his name again?
Xenon, Your Honor.
Mr. Xenon is not allowing the officer to arrest him by putting him in the car.
Respectfully, Judge, the officer doesn't even have to be arresting him. They just have to be looking into any legitimate matter. And then he's interfering with that. And I will say, if he'd already been in the car 3 times, like defense pointed out, I would think he wouldn't need help getting in. So to us, it appears as though he's trying to push out. The officer has to put his hand on his chest to push him back into the car and then take his legs and place them into the car.
He was cooperative the whole time. He's on his mom. If anyone's aggressive, it's the cop from the beginning.
Judge, the
And
cops-
I ask at the court's discretion, watch the video. You only need to watch like 2 minutes, the 13 to 15 minute mark, Your Honor. I mean, that's all you really need to watch on this.
Judge,
Watch or no?
We can watch the video, Judge.
Cue it up. Let's watch. Can you put it on the screen somehow? So we can all watch?
we can just go to the back and watch it. Do you want to hook it up?
No,
I
why
don't,
not?
because he has issues hooking his computer up to the technology. Yeah, it's this one. Judge, did you want to watch the whole video or did you?
No,
wanna-
just the relevant portion. I don't need to see the whole thing. No, just that part that's relevant. You know, I guess if you wouldn't just put it right there and just turn it around,
Yeah, just put it
just
up
right
there.
there on the table. Yeah, right there. And set it.
I'm just turning the volume up, Judge, as well.
He talking about don't let him pull up. They talking about I got a warrant out for Fort Bend County for assault. Look, he pushing me. Mama, record me. Mama, look. Mama, look. Record him.
Now you're under arrest.
I'm under arrest.
Yep, you
What?
got a new charge, Bubba. Resistant transport.
Resistant. I wasn't resisting.
You just resisted transport. Yep.
What the hell is that?
Now you got a new charge. Yep.
Come on.
Thank you,
This
Judge.
officer's not working intake, Judge.
Really? That's it?
That's it, Your Honor.
That's the relevant portion that defense is.
Oh, come on.
The officer is investigating legitimate.
I know, but no. All right, I'm
Do
with
you
you.
see why I'm so upset, Your Honor?
All right.
Okay. Thank you.
You can refile this as resisting.
Yeah, look, yeah, I mean, you're not gonna hurt our feelings. You need to do what you need to do. Perhaps it was the wrong one, but yeah. Was it resisting?
Nope.
My name is Bennett and I ain't in it. But no PC.
Thank you, Your Honor.
I like that there. They got no PC for that. Most judges wouldn't have been as patient as Judge Fleischer was there, but he did good there, and you can just tell Greg was having none of it. I know a good way for that guy to keep from getting more charges, stop getting interactions with police. But thank you so much, Kelly, for the super chat. That's always fun. Thank you so much for that. How about we go to Judge Hagen? She's always fun to watch, and she gets a little fussy with a guy.
We will go on the record in the matter 23 CF 124, State of Wisconsin versus William Standiford. The state appears through Assistant District Attorney Kevin Schmidt in person. Mr. Standiford appears by video conferencing in custody in New Lisbon Correctional Facility. We're here today for a hearing because Mr. Standiford, you have written the court numerous times requesting that the court do a judgment or amend the judgment of conviction to lower the amount of restitution taken from the Department of Corrections. And I understand your correspondence that you have written to the court in that you only receive a small amount of money put into your canteen fund or your other funds, and that once this is taken, you're left with very little amounts to be able to essentially pay for necessities such as toothpaste or toothbrushes and or anything else that you would like to get. I see that you have paperwork right there, and I'm not sure if you have anything else that you want to add or you want to state before I ask anything from the state and before we move on.
It was just paperwork that's showing what they're taking from me and what amounts that they're taking. That's what I was gonna address the court and show the court.
Okay, you can go ahead and provide me with your information.
Well, I just wanted to show that I'm a special needs worker. That's what I do for a job here. And I get $15 every 2 weeks. And by the time they take everything for restitution, they're taking 50% right away for restitution. So that's down to $7 automatically. And then from there, then they take victim witness surcharge, 25%, crime lab, DNA surcharge, another 50%. They just keep going down the list. And court costs, the next big thing I have after my restitution is court costs, which is $2,596. I'm just asking the court, when I'm released, if I can pay these things upon release, where I'm able to make some money anyway. I mean, $15 to pay for personal hygiene stuff every 2 weeks is all I get. I mean, and after they take everything out, I'm left with maybe like $2, $4 a month to live on. My family sent me money a couple times, $300 on 2 separate occasions, and out of the $300, I got like $100, $115 is all I got out of the $300 sent to me on 2 separate occasions. So I'm just asking the court not to make it so I don't have to ever pay it, but wait till I'm able to pay it anyway, if that's possible, Your Honor.
And before I ask anything from Mr. Schmidt, you shouldn't be paying, or at least it's my understanding that you shouldn't be paying the court costs or DNA surcharges or anything right now until restitution is paid.
Right. Well, if you drop my restitution, that they're gonna go right into the next one, is what I'm trying to say. You're right on that they're not doing that until after my restitution is paid, but that's what they will be going into. So, I mean, if you just stop my restitution, that's not gonna really help, because then they'll start taking the court costs and then, and what, they'll just go down the list. And each one of those is like 50%, for court costs, 25%, and then they just keep going down the list, and so just stopping just the court, I'm asking you to stop the restitution and any of the fines or fees, maybe until I get out. So
Right, but they should not be taking fines or fees or anything, or the DNA surcharges or any surcharges right now.
No, they're not. No, they're not, Your Honor, but they're just taking just to the restitution. And then I have child support that I got a hold of Minnesota, they dropped that down to $10 a month. But yeah, you're right. They're just taking it just the restitution, but that's 50% of anything I have sent in. And if you stop that right now, then they're just gonna go on to the next one. So
Yes.
I mean.
Yes. And I understand where you're coming from, and
I just want to hit pause there and thank Fozzie for gifting the memberships. I don't know how in the heck you got Kelly Newell, Dead Slash, Snoopy, Junebug, and who else was it? I've never seen someone gift memberships and it goes to someone we know on each one of them. So thank you so much, Fozzie. That was awesome. Not Ladylike was the 5th one. Got some big names there, Fozzie. That was good. Victorious being thankful to you, Fozzie. But we got Snoopy Green, we got Junebug Green, and there we go.
I can't do what you're asking me to do, and here's why. I'm going to have Mr. Schmidt, he's going to read to you, most likely, as he has his computer, the statute that prohibits me from doing what you're asking me to do.
Yeah, the statute you're probably referring to is 97320 sub 11 sub C. In 2015, the legislature passed a law that stated when someone's in prison, it's the Department of Corrections that has the authority to determine an amount or percentage reasonable for payment to the victim. So the court has no authority to reduce what DOC decides is reasonable. If Mr. Standiford would want to contest that, he'd have to do something with DOC.
Yeah, so Mr. Standiford, I don't have any authority to state that there's a stay on your restitution, or to say that as to any fines and fees or restitution or any payments that you don't have to pay anything, or limit it to just a $10 a month or anything of that nature. It's out of my jurisdiction and my authority. It's now in the hands of the Department of Corrections since 2015. Because that's what the legislature did in that legislation and that statute. So your plea is really to the Department of Corrections.
It doesn't make much sense, except you're the one who sentenced me to the 8 years, Your Honor. DOC has no say in that, other than now they do. Now they're saying, no, your judge says you gotta do 8 years. Okay, well, why can't my judge, who gave me told me to pay the rent, I paid $5,000 to the courts when before sentencing, and it's like, I don't know.
Mr. Standiford, the reason why I wanted to have the hearing is so that you can understand that. And I understand your plea. I truly do. And I understand your argument. I have those same feelings. Why doesn't the court have more authority over certain things such as that? And there are other things that I wish that the court had more authority over, in which the Department of Corrections then takes the authority after a sentencing. Okay. I understand your frustration. I have similar frustrations, but for different reasons, because I understand where you're coming from, Mr. Standiford, because I don't think that you should have to go without having personal hygiene.
I can't live on $2 a month. I can't, and it's not my family's responsibility to pay my restitution.
I completely understand that. And I'm going to tell you, and I'll state on the record, that you were the one that did pay the $5,000 towards the amount of restitution that was ordered. And it was a high amount. I don't have the total amount off the top of my head, 17,000, or it was $22,700 and some odd cents was the whole lump sum of that restitution that you share as joint and severally liable with co-defendant Jamie Blackerby. And I understand that you said that you may not have known Miss Blackerby, or you may not have been specifically in cohorts with Miss Blackerby, but together this crime was committed together with Miss Blackerby. So it's a joint and several restitution owed by both of you. Honestly, you were the one who is getting hosed in this matter, if I can use the word hosed, because Miss Blackerby has not paid anything towards the restitution, and you paid $5,000, and now you are not able to survive or have certain things in prison. And I understand that you make a very small wage in prison. $15 every 2 weeks is not a lot of money.
Yeah.
And so all I can say is your direction is to write to and talk to the Department of Corrections and see if there's a way that they would limit the amount or reduce it from 50% down to maybe 25% until a certain period of time.
Well, how about modify my sentence to concurrent rather than consecutive?
Well, I can't do that, and you're not in front of this court for that issue.
No, I'm not.
So that's the only reason I had this hearing was so that I can let you know that it's out of my hands. But I do understand where you're coming from, and I do understand your frustration.
Well, I don't really think you understand totally, but Mr. Schmidt seems to think it's funny over there.
I don't think he thinks it's funny. This is not, it really isn't funny. I believe that you work very hard at your special needs job. I truly do. If there was something I could do, I would. It's not in my power or my authority to do. If I could, Mr. Standiford, because I know that you are a hard worker, because I know that you're making changes, because I know that you're rehabilitating, I can see all of those things in the letters that you're writing to me. I know that you're working hard at your job and you're not making a lot of income doing so, and that you do need certain things while you're in prison. I understand that. And that's why I wanted to tell you, if I could do something, I would do something, but it's out of my hands.
Yes, ma'am.
So your step is to write to or talk to the Department of Corrections. That's the first step, and that's where you need to go.
It's a bigger bureaucracy and a lot more bullshit than I'll ever be. I can't even get through to the courts that sentence me, let alone to that bureaucracy at the DOC.
Oh, you got through to the courts. You got through to the courts, but
half of you, like you're right, but there's no way the DOC is going to do a damn thing for one man. They've got Wisconsin's got thousands of people in prison.
Mr. Standiford,
one little voice, William Standiford, complaining about bullshit. They're not going to do a damn thing.
Mr. Standiford, now I have to say you have to watch your language. You are in court, but
yes.
they may, Mr. Standiford, you don't know. A lot happens with one voice and one request. And it's worth a try to write to the Department of Corrections. It's worth a shot to write to who is your agent. It's worth a shot. And or it's worth a shot to write to your agent and see if there's somebody above that agent who they can direct you to write to that person. And you have the time.
Yeah.
And you have the will and you have the drive.
I'm losing
it's
all
worth
that.
A shot.
But I don't have the money. I get $2. It's going to cost almost half of the money that I get to send a letter, because the stamps are 80 cents. Hello, that's nearly half of the money that I get a month, or every 2 weeks, to send one letter that's going to be laughed at. It'll take them 2 months to get me back a reply saying, sorry, the legislator says in blah, 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 that you guys aren't worth it.
Well, Mr. Standiford,
I
disagree. I disagree with the statement that you said that you're not worth it, or that people in prison aren't worth it. I know that you may feel that, or you may feel that that's what some people feel, but I'm sorry that you feel that way. And I'm sorry that it takes a lot of money to send a letter. And now I don't feel so great that you sent so many letters to the court and there's nothing that I can do.
I'll deal with it like I have this almost 16 years that I was sentenced to.
All right, Mr. Standiford, I do have to move on. I have a 2 o'clock.
All right, thank you, Ms. Moore.
Thank you. We are adjourned.
All right, I guess that's the time for me to start talking. Thanks everybody again for coming in there. We got a pile of people in there. There was somebody that made a comment there a little bit ago. Yeah, everybody go check out Court Vibes. Fozzy's throwing up some videos on there, and let's all go and support it. And make Court Vibes a network over there, make it have all kinds of stuff over there. She's doing the O.J. Simpson's trial during the week. I think that's for members only, but the memberships over there are well worth the price. So go over there and check it out. Thank you guys so much, Snoopy for the super chat, and Fozzie for the memberships, and Kelly for the other super chat. Thank you guys so much. We're going to jump back over to. Let's jump back over to another Judge Fleischer one. He had a little bond violation. If you remember, probably a month or so ago, a guy was in there beating on his grandmother, and he felt that just because of his age, he had to be able to live there. Well, of course he violated bond, and so this is a judge giving him a run in for it.
Yes.
Tristan Smith. Now, Mr. Smith was on docket yesterday. I came in, I didn't see him.
He didn't come in.
I know he did not. I did. And then I came back afterward, but docket was over at that point. This is the one, he's 17 years old. There was the issue at his home. His grandmother no longer wanted him there. And so he didn't have anywhere to go.
I remember.
That long discussion, yes, sir. I understand he's been staying with a friend, but he told me that he's been sleeping outside for the last few days. And that he could not get here. He had no transportation. I've been talking to him for the last 2 days. I told him to Zoom in, and if you were unable to make it, then at least Zoom in and let the judge see you, and judge will have to make his ruling.
I need him here.
I understand.
Drug test. He's not here. So
Understood.
I've already given him one pass. Can he get here to take a drug test today?
I doubt it, Judge. I mean, I've been talking to him all morning since I've been working. He just doesn't have the means, and at this point, doesn't have a place to live, is what he's telling me.
Okay, so I just found out the OJ thing is a free stream. So that means everybody needs to go over there and check it out. There's no reason not to. So go over there and support it, and go ahead and click on the membership anyways. It's the least thing you can do over there to help her. So, but we're going to, yep, absolutely. Fozzie's being smart there, posting comments from 45 minutes ago. Absolutely. I went to go check on something, and it threw me back at the beginning. But as far as it getting cold, you guys that live in these cold states, I don't know how you do it. I left from South Carolina late last night and got home today, and I'm still having moments of shivering. I don't know how y'all do it. So, nope, that's certainly not going to work. But all right, Amanda, get up with me on Discord. We'll talk about that issue you had a little bit ago. So we'll do that on Discord. We're not gonna do it here, but someone had said that they called BS on this guy. Absolutely. So I love how confused he looks, here, just acting like he didn't know what he did was wrong. So here we go.
Mr. Smith. Tristan Smith.
Hello?
Tristan Smith.
Hello?
I can hear you.
Oh, okay.
I am disappointed in your behavior now, Mr. Smith.
Sir.
You have bond conditions that you were supposed to live up to. You have failed to live up to those conditions.
Yes, sir.
What I'm going to do is I'm going to give you a courtesy to come here on Monday to come take a drug and alcohol test. If you fail to come on Monday, then I'm going to revoke your bond, and I will issue a warrant for your arrest.
Yes, sir.
You, Mr. Smith, have to understand you probably don't have anyone in life that is prepared to bond you out of jail if you go there. You need to keep this in mind. Where there's a will, there's a way. You can make it here to downtown to take a test. It's not a matter if you can, it's if you want to. You can find a way, and I expect you to do it on Monday.
Sir.
Do you understand?
Yes, sir.
Let me make one more thing abundantly clear to you. If you ever miss another drug and alcohol test, I will issue a warrant for your arrest.
Yes, sir.
Do you understand?
Yes, sir.
Okay,
Thank you, Judge.
that's it. I'm not gonna entertain any more excuses. I don't, that's it. Okay, all right. So on Tristan Smith, SFBF Monday, must be here. And on Stevens, just a normal reset, pending results, I guess. So if it comes back, then hopefully. We're sending her for, no, we'll just send her on her way. If it's dirty, then we'll deal with it next week. Which I'm keeping my fingers crossed. Ready?
Hey, Judge. Okay. Yes.
Come up, Mr. McDonald. Morning, sir.
Thank you for seeing me, Judge.
Of course.
Come before you. I don't really know what I'm doing. I just know that I came before you and I was from out of state. You tried to help me and I was kind of telling you that it was going to be dismissed anyway. I was here 9 days. They shipped me to Arkansas for 30 minutes. It was all done. Said to be dismissed on the 9th. However, the police that stopped me had my car towed and put a card in my property. And so my car was sitting there the whole time. And so I had to find my way back to Houston. Since I've been having Uber back and forth to try to, and I couldn't get my car. It was $540, now it's $1,400. They said, look, you got 4 days, sir, and we're gonna auction off your car. But then they said, if the judge you went before, if he gives you an order, we will release your car, zero balance. Again, Judge.
I can't give you an order to give you your car back. That would be me, in essence, ordering a company that does business to lose money to give you your car back because you don't want to pay to get the car back.
I don't want them to lose money. The thing is, my car was towed erroneously. I was at home. That's why I want to show you the police report. I was at home.
To file a complaint with the police, internal affairs. If you're telling me that something was done illegally, immorally, or whatnot, you need to file paperwork with that appropriate agency. But I cannot order a private company to return something to you. I don't have that kind of jurisdiction.
What do they mean if you get a judge's order and we release it?
Maybe a civil judge's order. I'm a criminal court judge. The only time I can ever order any kind of property returned would be if it's confiscated by the state and they're holding it. So let's say you get arrested, you get pulled over, and you have a gun on you, right? They take your gun and they put it in the HPD property room, right? In that respect, under certain circumstances, I may be able to order them to return it because it's in the care, custody, and control of the state via HPD. Here, your car was towed by a private company and they're holding it, and it sucks. I get it that the bill has ballooned as much as it has. If you ever have a problem, you can always file a complaint with the bail bond, not the bail bond board, but there is a actual board for, there's a towing board too, isn't there?
I'm looking at it, yes.
It's a towing regulation.
There's
a request for a hearing, but I'm reading that it's got to be before the 14th day after the vehicle was removed, is that you have to submit a tow request. The forms are all here. It's 50.
And maybe the fact that you're in custody may toll. I don't know, but I'm not versed on that kind of, and I'm not, number one, number two, I'm not allowed to even give legal advice, but I don't know. But I can't order them to give you your car back. That would literally be me telling them, hey man, just forget about all the money that you've made by holding the car, just give the man his property back. I can't do that. I don't have the jurisdiction. Maybe a civil court under certain circumstances may order it back, but you'd have to file a lawsuit. You'd have to file some kind of paperwork.
All right, well, I'm gonna pray for a miracle.
What I would do, perhaps, can you get on a payment plan with them and say, hey, look.
Try that. they zero tolerance. I mean, honestly, I
And I have to understand, because imagine how many times they've probably gotten yanked,
who knows?
you know?
I wish.
Theoretically, even if I were to give you a court order now, they'd have to, my guess would, they would hire a lawyer, file a motion to quash my order, saying that, hey, he doesn't have the proper jurisdiction to do this, right? And then they may come after you for attorney's fees. Just.
My manager's like, hey, man, if you go to order, I'll release your car to you. He understood what happened. He said, man, just bring me something. I'll release it to you. I'm like, okay, I'm gonna go try it.
And a lot of times they say stuff just to get you out, but I can't. I'm sorry. But like I said, perhaps if you talk with the owner, you may be able to negotiate something with them. If you talk with if you talk with someone who has no power to negotiate, you always, if you talk to the right person, if you talk to them at the right time, you may get what you want. So don't go to them at 4 o'clock in the afternoon because they've been working, they're tired, they've probably dealt with a lot of people, all they want to do is go home. But go there first thing in the morning, try to get to the owner and say, hey, look, here's my circumstance, here's the proof, work with me. I want my car back. And I don't know, what do you think? Anything else, Freya?
No, I'll help him out with the tow lot information, and I also have got a copy of HPD's agreement with private tow lots, so that maybe that can help him out.
Thank you, I appreciate it.
Yeah, I'm sorry. But, you never know, it doesn't hurt to try. So just keep trying it.
I'm praying for that.
Yeah, look.
Yes. Thank you.
Okay. Hey, Stephen. Thanks.
I'm here on behalf of Mr. Naylor this morning with Mr. Jones, Your Honor.
Come up, Mr. Jones.
Mr. Naylor is in Cancun until Monday of next week, Judge, so he's not available this morning.
I
So I'm kind
understand.
of filling in. I have had a chance to look at this violation report regarding missed blows. I'm assuming that's our issue here today. Spoken with Mr. Jones about that. Pressed upon him the need for perfection here.
This is no tolerance. Absolutely no tolerance, because we've had one issue after the other. Testing positive for here, doing that over there. We've literally let you go over and over and over. And there's absolutely no excuse for the missed blows. How many missed blows do we have?
Says 19, Your Honor. That's 7, within that 7 are included. But Judge, I would ask if possible, as I'm not the lead on this case, and I know Dustin has had history with the court and Mr. Jones here on this case, if you would consider holding on the consideration of this matter until he returns on Tuesday of next week. So that he can
I'm
hear it.
sorry, Ben, I can't. I have to know, you have to know that we mean business. I'm not here to toy with you and play games with you. Know what the expectation is in this court. You've been with me for as long as we've had. You're over there.
Because I have a cold, y'all, cold weather. I apologize. So can I please speak on the breathalyzer?
No.
Just
You
told me
know
that
what
last
the expectation is. You have 19 missed tests. That's it. I'm sorry, Ben, I can't. You're here in his stead. You're a capable and outstanding lawyer. I have the utmost respect for you, but 19 missed tests are 19 missed tests. And I've been telling him since the absolute beginning, there's just no tolerance.
Please,
No.
But to his credit, Your Honor, we have no positive UAs. He's been here on weekly UAs, so there's no indication that he's using this to obfuscate, for alcohol.
I go to sleep early, man.
Test, and he is blowing outside the window, so we don't know what he's doing.
Oh my God, sir, I go to sleep at 8 o'clock every night, sir. It's just the 10 o'clock ones, and I get my 5 o'clock one first thing in the morning, Your Honor.
Then you come here and you ask.
Oh, they just told me about this last week in pre-trial over there, and they said
Look
that I
at
had
you.
the 45-day miss.
You have 19 missed blows, dude. Covering the camera.
Please, Honor, I will do anything. I'll even go on that drug, ankle monitor. I'll do anything, Your Honor. I'm really trying here. I swear to God, I'll do anything you want me to do if you just please let me stay free. I swear to God, Your Honor, I'm really trying here. Please, Your Honor, it's just, I don't even drink.
From the 15th of November, You have been skipping tests. You have been to this court.
I go to sleep at 10 o'clock and I still did the ones later on when I would wake up, and they told me this just last week, Your Honor. I swear to God, I swear on everything I love.
You know.
Please give me a chance, Your Honor.
Testing schedule is, and I've given you one
I started
pass
on-
after the other. He goes with you. No.
Oh my God.
Your Honor, may we discuss setting a new bond for?
Of course.
Oh my gosh. Your Honor. Why? Please, I'm trying here. I'm trying to do everything.
Goes with you.
Oh my gosh.
Bond is at 5,001 now because of the prior violations. I will now set it at 10,002. I'm sorry, Ben, but he's tested positive literally over and over and over. He continues to test positive for marijuana. When I've told him to stop, he's tested positive for opiates. He's tested positive for this. Now he's skipping blows. He has obscured the camera as well?
It's not necessarily that he's obscured the camera, but it's too dark to view it. It doesn't mean that there's.
It's the same thing. If we can't see you in the camera, then you're fooling. And I'm done with the fooling. That's it. I know that Dustin's gonna be pissed, but I mean, I've got it in black and white. And Dustin knows that it's no tolerance.
Consider 7502, Judge, for bond.
Okay, Ben. Okay, great. But he has to know that we mean business, man. If I let him go now, I'm enabling, and I'm not gonna do that. I can't, but fine. Because, fine. All right, 75, okay? Good morning, Mr. Duvall. Sir,
I didn't see this one here. This guy just looked like he'd be fun, so I threw it on there. So I haven't seen this one yet.
charged with assault causing bodily injury. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. The officer was dispatched to a residence in Harris County, Texas, in response to a disturbance with a weapon. The complainant advised that she was in her home when she heard someone knocking loudly on the front door. When the complainant's husband, the witness, opened the door, he and the defendant started arguing. The complainant stepped between them to try to stop the fight, and the defendant shoved her, causing her to fall to the ground and hit her head, causing pain. The witness told the officers that when the complainant fell, the defendant called her a dumb bitch. And when the officer spoke to the defendant, he stated that he went over to the complainant's house after the complainant and the defendant's wife got into an argument. The defendant then stated that the witness chased him with a machete and a baseball bat. The officers did not find either of those items at the location.
Who said that?
The defendant stated the witness chased him, but the officers did not find them.
Okay. Do we know if she still wants to have contact? Have you got the rip done?
The rip was done.
Yes, Judge, I spoke to this complainant. She's requested no contact. I think they're neighbors. They live about a mile away from each other. And then she's just requested that he's not allowed to come to her property either.
Okay. But the bad blood is, I guess, between the gentlemen as well, though.
I think it's between
Right.
both families. She explained to me that there was a argument that was started a couple months ago, just between them, and then it's kind of been ongoing since then.
All right, Mr. Duvall, I'm going to find that there's probable cause to go forward with your case. Don't have contact with these people.
Yes, sir.
I see there's bad blood, but it's just not worth it sitting in a box 6x9 for months on end because it's just some bad blood.
Yes, sir.
Just don't go back over there. Don't have contact with them. Don't be in possession of weapons, and then everyone's happy.
One question, that is my aunt's house. So sometimes I do have to drop stuff up
I
there.
would use someone else.
Yes, sir.
The problem is that I don't want you to go over there.
Yes, sir, I understand.
One day they're accidentally there, they start popping off to you, and then boom, you're the one that's on bond for this case. So even if they call the cops and it's not true, and they start, fibbing and saying this, the cops come out, they're gonna be on you because you got the open case.
Yes, sir.
So when you get into a pissing match with people with authority, 9 times out of 10, you're just gonna lose, right? So it's best to prevent all that, so that's why we do this.
Yes,
So
sir.
just don't go over there, don't have any contact, and then we're all happy.
Yes, sir.
What do you do for a living?
Construction.
Do you have the ability to hire a lawyer?
Yes.
What kind of money do you make a month?
Well, I just got back to work. I make right at 25 an hour.
Okay. If you want time, I can give you time to hire a lawyer. If you have any issues and you're unable.
I use Juan Vasquez. Juan Vasquez.
Okay. Is that, you want to go hire this person?
Yeah, I will hire him. Yeah.
Okay. So what we're gonna do now.
I was told that I didn't need a lawyer because more than likely this would be thrown out.
Do that.
Mr. Vasquez, it says something.
I don't see how anyone can say that without.
Because
Okay,
I didn't.
So we got a bunch of DAs here. Everything you say is recorded. They use it, so just don't. Better to have the lawyer work on it to try to work it to your favor, but just don't say anything now because anything you say, they're gonna use it against you. So I'm gonna have you sign a reset with Ramona. We'll have you take a seat in the jury box. I'll get your bond conditions. We'll have you sign it, and then after that, you'll be free to go.
Yes, sir. Thank you.
Come on this way, sir.
All right, I think we're going to go to Judge Simpson. I think we're going to get Judge Simpson and knock out the rest of this show. Thank you all for sticking it out. Let's go see what he's got.
Court calls the case, People versus Tariq Day.
We're ready in that matter. Warren Brown, Deputy Public Defender, appearing on behalf of Mr. Day. I believe Mr. Day is appearing by video. Mr. Day, could you state your name for the record?
Tariq Day. Thank you, sir.
Today is the date and time set for the competency review.
Did you guys get a new report?
I believe I did contact Ms. Hughes. She sent me a copy of the updated report. I was able to review it, and we should have
I have an order.
Yes.
I don't see a copy of the report. I don't have a copy.
From way back in September.
I do. That's the one. Okay.
That's the one.
All right. So there's no other additional evidence?
We have no further evidence to present, Your
Honor. All right. And nothing else from the people?
Thank you, sorry, nothing else.
All right. Based upon that report, the court would find at this time then that the defendant is competent to stand trial. Specifically, the court would indicate that the defendant can understand the nature and objects of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is deemed competent.
This is the fella that probably a month or two ago had, tried the sovereign citizen defense, and I think it sounds like he's trying a little bit more of it again. It's not going to work. He was the one that the judge told him he had to be there at 3 p.m. and of course he had COVID, but he could be at work but couldn't show up for court. And Marty asking how does he keep that hard hat on? It's amazing. He can sit in the truck with a hard hat on, and anybody who's tried to get in a pickup truck with a hard hat on knows how tough that is. But this guy is knocking it out. So, Victoria, go take care of the kiddos. Thank you so much for coming out. We'll see you in court tomorrow, Victoria. Thank you.
And now we would respectfully request that the probable cause conference be set.
All right. 2 weeks out work for you?
Yes, please.
All right. I'll set a probable cause conference then for December 19th, 2024, 9 a.m. Bond continued.
Thank you.
Question.
Yes, sir.
In regards to the competency hearing, it was not only to see if it's stand trial, but it was more so to make sure that the court felt I was competent enough to defend myself, which is still my stance.
I think what he's saying is that he wants
The criminal responsibility. Is that what he's talking about?
No, there's not criminal responsibility.
Request
or assessment.
Okay.
But Mr. Day, if you contact our office, we'll let you know. We'll answer your question. And if you're asking to represent yourself, which I believe that's what you're asking to do.
Oh.
Mr. Day? Is that what you're asking the court
Yes,
to allow
correct.
you to do? So we can have some conversation.
Okay. Right. So you guys can talk about that, Mr. Day, if you're going to represent yourself, or if your decision is to do that after you talk with the public defender's office, you'll need to appear in person on the 19th. It will not be over Zoom.
Is there a reason for that?
Yeah.
Well, first of all, because I said so. And secondly, if you are going to appear You are the defendant and you would then be counsel. So I want somebody before me.
Oh, somebody, okay, because you said so, it's kind of a discriminatory.
Mr. Well, because I said so, that's how this works.
Mr. Dave,
I'm done. Bond continued. I'll see you guys on the 19th.
contact our office, Mr. Day, and we can have it.
Adios.
All right, cut him, please, before I say so. Good.
Good morning, Your Honor. Marcia Creature on behalf of Mr. Montano.
What are you gonna do if I deny Mr. Moon's motion?
I'll be in big trouble.
Oh, okay, all right, I'll grant her motion to withdraw. Go ahead, Kevin.
Good morning, Your Honor. Marcia Creature on Mr. Montano. We'll be seeking an adjournment in this matter. He's in federal custody, I believe, at the moment.
All right, Mr. Montano, can you state your name, please, sir?
Yeah, my name's Alejandro Montano.
Thank you, sir. All right, you understand that your prior counsel is withdrawing and you have new counsel. You understand that, sir?
Honestly, I don't even know what's going on.
If I may, Your Honor?
Only if you're gonna clarify it.
I am.
All right, go ahead.
Okay. Your Honor, I was just appointed on this case, I believe, yesterday. And therefore, Mr. Montano is in federal detention. And I have sent a request to set up a meeting with him. I believe you're in Hazleton. Is that in Minnesota, sir?
No, that's in West Virginia.
West Virginia, okay.
Close.
It's been open
Maybe.
a year
So-
and something. I don't know what's going on with this. I don't know why y'all keep pushing
So,
it.
sir-
I don't know what y'all got going on.
Okay, hold on a moment, sir.
So, Mr. Montano, I will contact the facility that you're in and make an appointment to come and not see you, but at least have phone contact with you, and I can explain that, sir.
See, that's what the last attorney said a month and a half ago.
I can't speak for the last attorney. I can only speak with what I'm going to do. I actually
I'm
was
saying
in
though,
search-
why would you come and try to talk to me the day before court or a day before court? You need to talk to me like as soon as possible, not whenever you
Okay,
feel
Mr.
like that, y'all. I don't know what y'all got going on.
Okay, Mr. Montano, so I don't know anything about them trying to talk to you. I'm gonna give enough time that they'll be able to try to contact you and to be able to talk to you before we get to the next hearing. The
Look,
other
the thing
thing
is, I've been in custody
Sir?
since May 3rd,
I know.
23.
And okay, you
This
done?
case is from May
or you
3rd,
wanna- I'll let you
23.
go. What? Okay, so here's what I'm gonna do. What is 6 weeks out?
January 9th.
All right. What I'm gonna do, sir, is I'm gonna adjourn your probable cause to January 9th, 2025, 9 a.m. Ms. Cratur will be in touch with you, and hopefully we can move this case along. All right? Thank you.
Thank you, Your Honor.
Receive a message, Your Honor, from 15th District Court indicating that Jermaine Jean Giles had appeared there bright and early this morning, thinking that their court date was scheduled for there. I was told that they sent him over here, but he does not have a telephone. I was unable to reach him previously, and he didn't have a phone to call, but they said that they sent him on his way. Fortunately, he's not here yet, but I would ask for an adjournment. And when he does reach here, I can let him know the date that the court set.
That was 15th District Court that let you know that?
I received an email this morning. That was the wrong person. Your Honor, I apologize. I do not have an explanation for Mr. Jean Giles's.
Seriously? Seriously, that whole thing wasn't about this person?
Just remember it because it's gonna come again. Apologize, here. That's why I had to double check, and it's not. I'm sorry, Your Honor. I don't have an explanation for why. I'll just give you this is the one, and so. We'll still ask for a.
Yeah, you get things mixed up when you're woken out of a dead sleep. Bench warrant, bond 10,000, cash surety. That warrant will issue immediately.
All right, we're going to go back to this. Thank you guys for coming out tonight. It's really good to see everybody. You know, we've taken off quite a few days this week, and we're going to try to get back into the swing of things. Try to get on a better schedule. I'm going back to South Carolina tomorrow, but it'll be under a little bit different circumstances, and so I'm pretty certain we'll be able to do the 8 o'clock show. The 3 o'clock show we're still trying to work on again, but we will figure it out, and we'll certainly set up some time to spend with you guys. Thank you so much. Y'all have a great night. We'll see you next time.